We're going to get going here this morning. Secretary, if you would, please call the roll.
Senator Gardler, Senator Carr, Senator McDaniel, Senator Mills, here. Senator Southworth, here. Senator Storm, here. Senator Thomas, Senator Wilson, here. Senator Yates, Senator Wheeler, here. Chairman Schroeder.
I'm here. We do have a committee, and we're going to get going, and we're going to bounce around the agenda a little bit because of people's schedules. But co-chair or Senator Wheeler, I'll let you do the introductions for us.
Thank you, Mr. Chairman. I'm pleased today to have with me Judge Amanda Perkins of the Kentucky Department of Workers' Claims. I've gotten to know Judge Perkins over the last approximately close to a year in my administrative practice. As many of y'all may know, Senator Turner and I probably do as much workers' compensation along with President Stivers as anybody in the General Assembly. I think that Judge Perkins, and what I've gotten to see through both her demeanor and her decisions, brings a very balanced and well-rounded perspective to her job as a judge at the Department of Workers' Claims. She has a background of practicing both for claimants as well as practicing as a defense attorney for the University of Kentucky, our state's flagship university. So I think she brings a perspective of both the claimant's perspective as well as the employer's perspective. I think such a well-rounded view is helpful in making what sometimes can be difficult decisions. I don't know that I can add too much more to that. So if you all have any questions, I'm sure that she is ready, willing, and able to answer them for you here today.
Members, any questions? Okay, seeing none, I would entertain a motion on Senate Resolution 89. We have the first, Senator Mills. I think the second, Senator Storm. Madam Secretary.
Senator Gardler, Senator Carr, Senator McDaniel, Senator Mills, Senator Southworth, aye. Senator Storm, aye. Senator Thomas, Senator Wheeler,
Aye.
Senator Wilson,
aye.
Senator Yates, Chairman Schroeder.
Aye.
I vote aye as well. We have a motion for consent. All those in favor of putting on consent, please signal by saying aye.
Aye.
Any opposed? Hearing none, it will be on consent. Senate resolution passes favorably with favorable expression. Will be on the consent calendar as well. Congratulations.
Thank you.
Mr. Chairman, if you would permit me, I'd like to maybe have Judge Harvey next, if that's okay.
That works for us. Welcome. Are you going to do the introduction again, sir?
Absolutely.
Okay. Whenever you're ready.
Yes, I actually did not really know Judge Harvey until the last few years when he was appointed. I think originally, I guess about 5 years ago now. Judge Harvey also comes from somewhat of a dual background, having practiced both plaintiff's law and defense law. Likewise, I think that any practitioner that appears before Judge Harvey will tell you that his knowledge of the law is extremely detailed and knowledgeable. He also has an extremely good demeanor with both the claimants and the defense attorneys, and really tries to find that middle ground on cases. Sometimes he has to make some difficult decisions. In fact, I think he even had to make a difficult decision to dismissing one of my cases lately. But what I would say about him is he has the courage to follow the law in the manner he thinks is right. Wasn't necessarily his fault. It was probably something that the General Assembly did a few years back that tied his hands. But he's a very excellent, was both an excellent practitioner by reputation and has also been an excellent judge. And I think that the Department of Workers' Claims and the Commonwealth can be very proud to have him practicing in that position, and I would urge that he be reconfirmed in his appointment as an administrative law judge.
Thank you, Senator Wheeler. Senator Turner.
Judge, I join with Senator Wheeler on both Ms. Perkins and the gentleman seated to our right, Mr. Harvey. So as a practitioner, I understand and have seen their opinions and I think I've had a case with Judge Harvey. So I join with Senator Wheeler in all aspects that he has made to you all.
Motion on the resolution.
Thank you, Senator Turner. We have a motion from Senator Mills. We have a second again from Senator Storm. Members, do we have any questions? Hearing none, Madam Secretary, please call the roll.
Senator Gardler, Senator Carr, Senator McDaniel, Senator Mills, Senator Southworth, Senator Storm, Senator Thomas, Senator Wheeler, Senator Wilson, Senator Yates, Chairman Schroeder.
I vote aye. Senate Resolution 95 does pass with favorable expression, and
Second.
there is a motion for consent from Senator Wilson. There is a second from Senator Mills. All those in favor of putting this on the consent calendar, please signal by saying aye.
Aye.
Any opposed? It will be on the consent calendar. Thank you. Congratulations. We've
Mr. Chairman, I'm honored to be joined by Judge Greg Allen, who not only is a wonderful judge, but also a personal friend. I think he's got his wife, Mary Grace, who many of us are familiar with, joining him here today. I think also many of us may know his father, Jitter Allen, who's been a lobbyist down here for many years. Greg is kind of interesting. I got to know him by the fact that probably over the first 10 years of my career, he was on the other side of 30 to 40% of my cases. But that did not stop us really from becoming great friends. His work ethic and knowledge of the law is as broad as really anybody in the Commonwealth of Kentucky when it comes to workers' compensation. He has served in this role in the past and did a wonderful job. I think that you would have found that his work product was amongst the best of any judge in the Commonwealth of Kentucky. He gets his decisions out on time, and rarely, if ever, are they reversed because of his detailed knowledge of the law. I was very pleased by the fact that he was reappointed to this position by Governor Beshear. I think that it's really one of the better appointments that I've seen him make in his capacity as governor in this department. And I'm sure Senator Turner can add a little bit to this as well, because we've both known him for many, many years, and he will be a great re-addition to the Department of Workers' Claims. I think that anybody that knows him will tell you that his fairness and his dedication to the job and the workers' compensation community is really unmatched. So it's with great honor that I would recommend my friend and colleague and our judge, Greg Allen, for appointment as a judge at the Department of Workers' Claims.
thank you, Senator Wheeler. Senator Turner.
Thank you, Mr. Chairman. I join with all the language that my good friend Senator Wheeler has said. Speaking to Greg this morning, he told me that the first deposition he took was in my office, and I added some questions for him. That's the kind of person workers' comp needs to do that, and he has filled all those roles. I've had many, many cases like Senator Wheeler has. Admiral in everything he does will call you, do anything that's needed to make that claim go through the process. As a judge, I've had cases, many cases when he was a previous judge, and I'm sure that he will just continue to fill that role. I'm happy for both him and his wife, and join with Senator Wheeler for his being reappointed and really supported by the whole bar that practices workers' comp. Thank you, Mr. Chairman.
Thank you, Senator Turner. Senator Webb, would you like to add anything?
Thank you. Yes, I've had the privilege of not only knowing Greg since he was young, but his grandfather, my father, were friends, and quite a legacy in the sportsman's world in East Kentucky. And, of course, his father, extraordinary gentleman that's contributed a lot to the Commonwealth. But he's an exceptional lawyer. He's fair. He's equitable. He's knowledgeable. And we couldn't ask for a better man to serve the position. Thank you.
Great. Good to hear. Members, do we have any questions?
Motion on the resolution.
Seeing no questions, we will take the motion from Senator Mills. I will entertain a second. Second, Senator Wilson. Madam Secretary, please call the roll.
Senator Gardler, Senator Carr, Senator McDaniel, Senator Mills, Senator Southworth,
Split my vote, Mr. Chairman.
Please do.
I'm voting yes, and I just wanted to congratulate all of our nominees. It's unusual that you get out of here without me asking any questions. We've had such great reviews that I don't really have anything, and I appreciate the detail-orientedness and really the focus on the law, because I feel like details are where it all happens, and often those can get overlooked, and that's where things start falling apart. But very appreciative of y'all. Thank you.
Senator Storm, Senator Thomas, Senator Wheeler, Senator Wilson, Senator Yates, Chairman Schroeder.
Vote aye as well. Senate Resolution 90 passes favorably. I will entertain a motion for consent. We have a motion from Senator Wilson. We have a second, I believe, Senator Mills. All those in favor of adding this to the consent calendar, please signal by saying aye. Aye. Any opposed? It will be on the consent calendar. Congratulations. Thank you to all the judges who came today.
Sorry
Thank you
I
for
was
traveling
late.
down.
Sorry I was late.
Oh, we understand. Next on the agenda, we're going to have Senate Bill 15, information only, and I believe we are waiting on Senator Westerfield. Yeah, let me tell you. Senator Girdler. So we put everything on consent. So I think, thank you. Here he is. We certainly understand. Take a sec, catch your breath. And so far for the audience, we have one person, I guess, signed up there on the line, waiting. Senator Westerfield, I believe what I'd like to do with our time, give you, say, 10 minutes or so, hear from whoever's online, hear what they have to say, and then give you the final word. As mentioned, this is information only, but it's a issue and a bill that has been around. I know you filed it last session. I think you've been talking about it for quite a while. So it's been out there.
I appreciate it. Members of the committee, you've seen this slideshow before, and I've abbreviated it for your benefit. No sense in going back through all of that again. Simply put, Kentucky needs to act in an area where we haven't got any protections in place. We have in Kentucky law breach notification statutes for the private and the public sectors, but that's it. We've got a consumer protection statute or framework and statute, but it doesn't carry or cover the digital space at all, and it doesn't do anything to provide all of us as Kentuckians, as people that live and breathe and work and operate and do business and live here, a way to have any control over our data in the digital space. Other states have acted. We're all familiar with the GDPR. If you've been on the internet and clicked on a cookie pop-up, that's the GDPR at work there. In more instances than not. That was in 2018. In 2018, also, Vermont had a data broker opt-out bill. In 2019, Connecticut acted, Illinois acted with some limited sort of small bites at the apple. In 2020, California's consumer privacy bill goes into effect. They actually passed that in 18, went into effect in 20. And then in 2021, Virginia and Colorado both enact their consumer data privacy bills. I looked at all three of Virginia, Colorado's, and California's, and actually started with a model bill from the State Privacy and Security Coalition between that and Virginia, and modeled mine after that bill. It's not exactly like it. There are some differences, but it's much closer to the Virginia bill than to the California bill, or I think Washington State's had one that's failed to pass. But in any event, the intention here is to provide consumers with a basic set of rights that are set forth in the statute. You each have also been given a summary, a bullet point summary, delivered a couple of weeks ago on your desk, and I'm happy to provide another copy of that for you. But I'm just going to give a couple of things here from it, from both the consumer side and the business side. Senate Bill 15 allows consumers to control their data by preventing businesses from using their information for tracking and from selling personal data to other companies for tracking and targeted advertising. And the bill protects consumers further by ensuring that businesses can only collect and process information for legally approved purposes. It puts control of personal data back where it belongs, and that's with consumers. It gives consumers the power to delete their data. It gives power to the consumers to ask for a copy of it, to ask to identify what data has been collected. I've shared this with you all before, but this was 3 years ago. Courier-Journal's homepage. I used to run an app. It's now a plug-in in my browser, but this is an app called Ghostery, and it can show you every code, every piece of tracking software that's running on a homepage or on a website of any kind. This is the Courier's homepage back in 2018 when I took the screenshots. You didn't agree to anything. You didn't have to look at anything. You weren't offered anything. But every one of those things in that purple box, every company there is running code on that website. And by just going there, you've given information. They may have tracked what kind of computer you have. Not much harm there. But it gets a little weird when they're able to identify the website you just came from. Or maybe you were ordering some medicine. Maybe you were searching for something that you don't want everybody in the world to know you were searching for. Or shopping for something you don't want everybody to know you were shopping for. Or it tracks where you click next. There's code on websites that identify where you mouse over on the page. You don't have to click on something. That capture your keystrokes even if you never hit enter in a search field. That sort of stuff goes on and consumers don't know. If you were to look and plumb the depths of the Courier's website and privacy policy, you'd never know who Moat is, or LiveRamp, or Crux Digital, or Polar Mobile, and identify what data they're getting, where they keep it, what they're doing with it, and you certainly don't have a chance to ask them for a copy of it or to delete it. I don't even know if it's anonymized or de-identified, still has your name or your IP address to it or not. No idea. And I shared this with you all, and this is an attention getter, and that's why I share it. But it's an attention getter for good reason. It's jarring. Someone asked, and this is from 2018 in the Dallas Morning News, and I've got the link to this if you want it. Where do people who go to Chick-fil-A on Sunday go for lunch the other days of the week? Or excuse me, on the other days of the week go to Chick-fil-A, where do they go on Sunday when Chick-fil-A is closed? Now you think about that for a second. What they had to know to make this map, not just what restaurants are open, but they had to know individual devices. And that this one device A is at Chick-fil-A at lunchtime Monday through Saturday. Where does device A go on Sunday at that same time of day? This company, Live Mobile Insights, is who reported this. How much you want to bet? There's not a single consumer in the world who has consented to sharing this information with that company. You tell me where there was a disclosure that shared, by the way, when you offer your location data, we're going to provide you our service, but we're also going to share it with this company called Live Mobile Insights so we can make this cool map for everybody to know where people go on Sundays for lunch. No one agreed to that. Now, here's the important thing. I'm not trying to stop the data economy. It's valuable. Small businesses in particular want to target customers. They want to build their base. They want to know who's shopping, who's thinking about shopping for something. I don't have a problem with that. I don't have a problem with that at all. There's a lot of value in that. The problem is that consumers don't have any control over it, and they're not kept in the loop on it. And that's got to change. It has to change. Because right now, Kentucky has no protection on the books for this. Now, you're going to hear opposition saying that this goes too far, that it looks too much like California's, or it's too much like the EU's GDPR, or that it's got horrendous provisions. They may not use the word horrendous, but they're going to make arguments that it's very frightening, and that one of the worst things is that we're having to do a piecemeal thing. We're going to have 50 of these policies. I'm sitting here telling you, I'd love for Congress to act. But do you want Kentucky to go without protections while we wait? This has been growing for 20 plus years. We can't wait any longer. So if Congress ever wants to come back in and do something, super. That'd be wonderful. But until that happens, Kentucky deserves to have a protection in place. And while Virginia's is good, I've improved upon it. A couple of things that have changed. How much time do I have left in the first 10 minutes here? Any? None? I want to highlight a couple of changes from the bill as filed and let you know I've agreed to a number of changes, and I'm agreeing to more. There's already a sub. Been working hard on the bill. Then I've got a sub that's in the works that's continuing to make changes, made changes last night. A couple of key provisions. There's a threshold for when this kicks in, how many customers you've got to have in your system as a business before it even applies to you. The threshold I included was 10,000. It's going to go up. I don't know to what, but it'll go higher than that. Virginia's, by the way, is 100,000, which is way the heck too high. That excludes a lot of businesses that do a lot of data movement. So it'll go higher than 10, but I don't know where that'll be yet. Or if you generate more than 40% of your revenue from the data that you collect. Importantly, we carve out and exempt more organizations than either Virginia or Colorado. I'm not trying to create a compliance headache by doubling up on the scrutiny that you've got to deal with. If you're already subject to HIPAA, this doesn't apply. If you're subject to the HITECH Act, which is related to HIPAA, this doesn't apply. The Graham-Leach-Bliley Act, which is in the financial institution industry space, if that applies, this doesn't apply. And I've added additional language in my sub that actually excludes affiliates of companies that are subject to GLB. But when the affiliates aren't, I'm going to loop them into the exemption. So we've got a broad number of exemptions that carve people out of the bill because I'm not trying to create a compliance extra level of headache there. If you've already got some other statute you've got to comply with that protects data or anything along consumer data, fine. It creates the rights, and then the other big one at the end that has gotten a lot of attention is the private right of action. And I want to finish my thoughts on this before, Chairman, if I can, before you have the others speak. So you've got Virginia and Colorado that have no private right of action and only enforcement through the OAG. You've got Colorado that has a limited private right of action, but only for data breaches. Everything else is through the OAG. And the preference, particularly from the business community, small and large, in fairness, and I get it, I completely understand why they prefer it. They don't want any private right of action. They want only enforcement with the OAG. Well, I want to avoid a full-blown private right of action for the same reasons. I don't want the trial bar to blow it up and file a bunch of nuisance suits and all that sort of thing. I don't want to create, with respect to Morgan & Morgan, an opportunity for Morgan & Morgan to come in and go after settlements from companies left and right, big and small. I don't want that. That's not my objective. I want to protect consumers and the data that they haven't given power over it. But I also have trouble with just pure OAG enforcement. When it's an OAG enforcement model, there's a political calculation before the OAG will act, right? No matter who holds the office, Republican or Democrat, there's a threshold at which they've got to meet before they're willing to do something. How big is the company going to be before they act? Or how many Kentuckians have to complain about Company A before the OAG thinks it's worth going after? Or they think it's even fiscally responsible to go after? If it's 200, what redress do the first 199 Kentuckians have? So the bill has a private right of action that is limited and allows no money damages at all. Zero. It is equitable relief only. In other words, you can ask for an injunction, and that's about it. and it's limited only to the 6 rights set forth in the bill. And after a conversation with the State Privacy and Security Coalition last night, or yesterday afternoon, which I found helpful, at least in some regards, because I've got an idea of what their concerns are, but frustrating because they weren't willing to negotiate a darn thing, and I found that very frustrating and infuriating. But even without their asking, I agreed to a further change to that private right of action. They brought up, if you have OAG enforcement, and they cited, I think, California. They said if you have that right to cure with the OAG, and this form letter goes out when someone complains, that 70%, and I have no reason to question their numbers, but 70% of those complaints are sorted out. That 70% of the people who are businesses that get a letter from the OAG saying, we've got a complaint here, you need to correct this, correct it. So I offered, and my draft, as of yesterday, Kirk, has the private right of action delayed until that right to cure has been exercised. So we're talking about a limited private right of action, which I have further narrowed down to just be on those 6 rights that we created in the bill, and that it can't be used until after you've given the business a chance to fix it with a demand letter. And I don't know how to make it more narrow than that. That is Senate Bill 15. I'm continuing to take meetings and get feedback from a lot of folks. Consumer Reports sent a really helpful letter just about an hour ago with a lot of praise for a lot of the bill and some some edits that they've suggested that actually are consistent in many regards with what the State Privacy and Security Coalition have asked for. And so I'm continuing to make changes to the bill, and I'll do that. But I appreciate the time to share remarks on it this morning, Chairman.
Thank you, Senator Westerfield. We do have questions, but I think the best way to go about this would be to go ahead and listen to our witness. Then we'll open it up for questions, and then I'll give you the kind of closing remarks near the end. So I believe on the line right now we have Andy Kingman. Andy is with the State Privacy and Security Coalition. Andy, can you hear us?
I can hear you all. Can you hear me okay?
We can.
Okay, fantastic. Morning, everybody. My name is Andy Kingman. I represent the State Privacy and Security Coalition. Before I go any further, I just want to thank the sponsor. We did have a very, civil and thoughtful conversation yesterday. I don't think we agree on everything, but it's always, we always appreciate when folks are willing to give us their time and attention. And, I think he ended up rescheduling a couple meetings to continue the conversation longer than we had allocated. So really appreciated his consideration and time yesterday and his thoughtfulness in trying to advance privacy. Our general viewpoint here is that workable privacy frameworks, it's important to provide robust and useful protections for consumers. We don't want consumers to be overwhelmed. We don't want them to be frustrated or to have their intentions frustrated. We do feel right now that as drafted, SB 15 is going to result in those burdens to Kentucky consumers. And I think, there are sort of 4 main issues that we've got with the bill right now. The first is this issue of the requirements overwhelming and fatiguing consumers. The second is that it's going to, end up making Kentucky less competitive because of the impacts on small businesses. It's going to require very lengthy notices. The enforcement is, as the senator mentioned, does contain a private right of action. And then lastly, that the bill is contradictory. Internally, it contradicts itself just because it includes elements from different privacy laws. So I'll speak to each of those briefly and then happy to take questions. But I think, dealing with, from the consumer point of view, our concern, and this may be where Consumer Reports is coming from as well, Senator, I'm not sure, but, SB 15 sets out these very lengthy, confusing privacy policy requirements. They go beyond every other state privacy law, even California's, and then kind of pairs it with a novel standard of the least sophisticated consumer. And we believe that the proper approach would be, more aligned with the Virginia model, which requires a clear, meaningful privacy notice that deals with categories of information and allows a much more concise presentation, which makes it much easier for the consumer to understand the types of data that's being collected, the types of third parties that they may, that they may be sharing data with, et cetera, et cetera. SB 15 also incorporates a European GDPR standard for using a consumer's data, and it will result in Kentucky operating as an opt-in consent bill for all types of consumer data. Now, this is something that US authorities from the FTC to California, to Virginia, to Colorado have all recognized, again, is overly burdensome from consumers. And those cookie banners that the senator mentioned are a direct result of that opt-in consent framework. And we believe that the proper use of opt-in consent is for sensitive information, and that consumers generally expect routine uses of data such as payment processing or shipping logistics to be handled without providing opt-in consent at every step of the way. And again, this goes beyond any of the US state privacy laws and beyond FTC guidance as to what the proper uses of opt-out and opt-in consent are. We want to make sure that consumers do not end up, as I think many of us do, just clicking through the cookie banners that pop up without reading them, that there is a meaningful opportunity for them to make informed decisions about the uses of their data. I think the other thing that we worry about in regards to the small business community is that there are fundamental tensions with other state privacy laws here. And we saw in California where the Attorney General's office put out their own study on what initial compliance costs would look like. And the initial compliance for businesses with fewer than 20 employees is $50,000. That's just a number that many small businesses can't afford to pay to stand up a compliance program here. For businesses with up to 50 employees, the cost was estimated to be $100,000. And so, we want to make sure that the implementation is as effective and cost effective as possible. And again, that you're still providing basic protections for Kentucky consumers that they would still have in this bill. We're not proposing to strike any of those, but that some of the startup costs to implement this bill would be reduced. I think the enforcement piece, it sounds like Senator Westerfield's making some updates. I think just a quick note, the AG does have authority right now under the Unfair and Deceptive Trade Practices Act that Kentucky has to enforce any unfair or deceptive trade practices, right? So if a business in their privacy policy says that they are not sharing data with particular partners, but in fact they are, the AG has the authority right now to pursue those types of claims. As written, SB 15 states that other independent causes of action are not limited. We have seen in other states, in Washington, that type of provision ended up being the reason that the privacy bill out there did not end up passing. And we've seen in California, the senator was correct in describing that there is a limited private right of action for data breaches in California. We still have seen the plaintiffs' bar institute over 200 complaints attempting to wrap in the privacy provisions of the CCPA and find some sort of backdoor private right of action that would allow them to continue going beyond the intent of the law. And so for us, we just believe that the Office of the Attorney General is the proper place for enforcement to reside. The right to cure has proven to be a very effective, low cost, low resource way for the Attorney General's office to respond to consumer complaints by sending a letter. And it doesn't have to be an investigative demand. It doesn't have to be an official investigation. It's simply a letter saying we received this complaint. Please let us know. Please provide proof that you've looked at this and resolved this. And the senator, said that correctly that 70% of the CCPA compliance has come through those type of low-level ways of ensuring that businesses who aren't in compliance come into compliance. So, our position is that that's the proper enforcement method. And the last piece that I just wanted to touch on briefly was this sense or the idea of the internal contradictions in the bill. And again, I would just say that these bills have been very carefully drafted, both Virginia and Colorado. GDPR was the result of a multi-year process, and they all kind of hang together as their own puzzle, where all the pieces are designed to fit together in particular ways. Here, this bill, again, it sounds like there are some changes coming. Happy to take a look at those. But this bill, that we're looking at right now, because it has some definitions from California, it has some operational provisions from GDPR, and then has Virginia, elements as well. It just doesn't really work together. And so I think those are the majority of our concerns sort of from a thematic standpoint here. So happy to take any questions. And thanks very much for your time.
Thank you, Mr. Kingman. We appreciate your testimony and opinions. We do have questions. I think I'll lead us off, and really I'll address it to you, Senator Westerfield, but if you're not sure, perhaps Mr. Kingman knows. You had mentioned in section 2, subsection 1, and then it's A, it talks about the 10,000, and I know you said you were going to raise that, and I had a constituent very concerned about that number, saying it's pretty easy to hit 10,000 in a calendar year. You had mentioned Virginia's 100,000 being too high. Is Colorado and California also 100, or do they have a different threshold?
Andrew might know the answer to that better than I do. I don't know what Colorado's, or if they have, or if it operates with a threshold, or California's. I don't recall where their bills stood on that. I think 100,000 is just too high. It's really easy to have it's not easy to get 90,000 customers, but that's a big company. That's a big processor of data. I think 10,000 is, ideally, I'm not going to hide the ball from y'all. Ideally, there wouldn't be a threshold at all. It apply to everybody that collects consumer data. I don't think we're there yet, and I don't think it's ever going to pass at that, not for a long time. But I think at some point, everyone's going to have to be responsible for doing this in a responsible way.
Mr. Kingman, do you happen to know if Colorado and California's threshold?
Yeah, they're all 100,000.
100,000. Okay, thank you. And Senator Westerfield, when you talk about collection of data, if I have a retail store and you come, for example, I'm selling clothes, and you come in and I have a credit card transaction and everything, I'm gonna hold that for my records. Now with this, is there kind of any exception for potential receipts and everything? I mean, to what extent are we scrubbing all the data? They would want to know that a sale took place, even if it was over a year ago.
So there's not a time limitation on that, and that's a request that's actually been given, if that's what you're getting at specifically. There's been a request, and I forget what group asked for it or what individual person asked for it, but they had a question about, and I'm open to suggestion, if this is responsive at all to what you're asking for, Chairman. They had a question about what companies do that have been around for 30 or 40 years, and they used to do everything only by paper, and then they convert to this. I know you're not asking that,
I'm not
but
really
there's
getting at that. I guess maybe to try to simplify it, if I have a product that offers a 5-year warranty, and in a year you turn around and want me to delete all your information that I have in my system, and I do that,
there are limits to the rights that are created there. So
Okay.
if it's essential to the operation of the business, there are things that you can't opt out of. There are things that can't be deleted. but again, the consumers given the opportunity to ask for that. Company doesn't even have to agree to it. There's even an appeal process built into the bill.
And that's I'll go there because I know other members have questions as well. So I'll jump to that section of the appeal process. If anyone's looking, I believe it's in section 3. You have, I believe, they have to invoke their rights 30 days, and Virginia and Colorado are 45. At 45. And I know you may extend by 15. I guess I was just wondering the logic instead of having 30 plus may extend by 15. Why not just have 45?
I wanted to make it more consumer friendly, but I'm not married to that. If the will of the committee or of the body or the legislature would feel more comfortable with 45, I'm not going to let the bill die for a 15-day difference.
I understand. Senator Wheeler.
Thank you, Mr. Chairman. And I guess one concern I have is why would you not have a monetary damage action? I mean, I see Section 9 that you allow the Attorney General to initiate and charge, fine them up to $7,500 for continued violations. But, I could see,
which I think is consistent with Virginia.
Tens of thousands of violations, and I can't imagine the AG's office may well have to set up an entire department to deal with this type of situation. But why would you not want the assistance of why shouldn't somebody be able to go out, especially if their data is breached and they suffer a financial harm? I think it's wrong to not allow them to collect on that if indeed they have suffered a financial penalty as a result of violation of this act.
I completely agree with you. Can't pass it with that. Not enough votes to pass it with that. I mean, that's just the unvarnished truth. And I think, with all due respect to the many, many lobbyists who've been activated on this bill, I think that's a line in the sand that they would fight against and their customers and clients would fight against. I think the political cost, I agree with you completely, but I think the political cost would mean the bill doesn't get through, and I'd rather have a bird in the hand.
Fair enough answer.
Senator Wilson.
Thank you, Mr. Chairman. And Senator Westerfield, thank you for this bill. I think it's sorely needed, something that we do need. My question is, in the Courier Journal page that you showed us and the list of all those people that are collecting data, does the Courier Journal, do they pay the Courier Journal to be on their site collecting this data?
You'd have to ask the Courier that, but I think it's a fine question. You can be certain that there has been some consideration exchanged between the Courier or its parent company and these entities here for the benefit of the data, one direction or the other or both. Now, some of these are add-ons for services that we'd all recognize. I don't see it on here, but when I run Ghostery on other apps, you see Adobe has certain things, or even Google has certain things that just make sure the right font loads on the web page. I don't care about that. And I don't think anybody else cares about that. That's not what I'm worried about. But then you've got Facebook Connect, and I know Facebook is a member of Meta, is a member of the coalition, I believe. I don't know if Google is. And they're the ones that we know. But again, you've got these others. But I guarantee you, I can't say I have firsthand knowledge of the nature or the details of the agreement. But the Courier is not going to give away their traffic for free or the information for free, or these companies won't either. And maybe we're sitting here, Senator, they may not get anything specific about you. And if they don't, then I'm not nearly as worried about those. But we don't know. And there's no way to find this out. And how many of you have ever heard of Ghostery before I mentioned it? How many other people are running this? In the new version of iOS and iPad OS, you can actually see a privacy report. And in the last 7 days, 49 trackers have been prevented from tracking my IP address from the websites I visit. And that number has been in the order of 200 plus for me on occasion, just over a 7-day span. So, yes, I'm certain there's an agreement somewhere that trades some consideration. I just don't know what it looks like. And neither does any other consumer.
Mr. Chairman, follow up. Well, I appreciate that. And of course, hearing the cost, it's been calculated that it would cost them for compliance. It would seem to me that if they're making money off of it, it would be a cost of doing business is compliance, as it is in every situation with business. You have a cost of doing business. So I don't know. That's just my thoughts on that. But thank you for the bill.
Thank you.
Senator Southworth, and then due to limited time, I think I have a couple more questions. So we'll hear from Senator Southworth. I'll have a couple more for both of you, and then we'll give it to you wrap up.
Thank you.
Thank you, Mr. Chairman. So I'm looking at this thing that we heard about with the companies and the 10,000 and the 100,000 and compliance costs. And I was going to ask a question about the compliance costs, but I think I maybe understand it, and I want to get clarification. So if a company has a website, let's say I have a website, all right? So I have a website, and my goal was to not have trackers on my website because I hate this stuff. But then, you get these certain deals, and it's like, oh, we can add to Messenger, but you got to have to add this pixel. Well, if I add this pixel, now I've got to put one of these little disclaimer deals and get everyone to opt in. So I had one agreement with one pixel on my website, and after that, I've got no more pixels on my website. Well, I'm assuming that my hosting, since I'm not self-hosting here, probably has some kind of stuff on there, and I don't even know what it is, and I'm the person that owns the website, supposedly. So this 10,000 or 100 or whatever it is in these compliance costs, is that really a compliance cost to
Not to you, it wouldn't be. Unless
Joe Blow website that small business sets up Wix.com, or is this more like Google Analytics needs to pay up? Or
it would be the company that's gathering that customer data and monetizing it in some way, gathering that data, and that's not you. I've got a Squarespace website, and I've got Squarespace's own analytics running on it, but I'm not collecting that. I'm not saving that. This doesn't apply to me, and that's assuming you don't fall under one of the other exemptions that are in the bill.
so I just don't see that it's actually a small business impact, because no small business I know, unless you're some really mega IT expert small business, has any clue how to harvest and use this data.
I think in fairness to Mr. Kingman's remarks, I think it is an increasing impact because smaller businesses are realizing the potential of collecting that data to build and learn more about their customers, or to grow and add more customers to it. So I think he's right that is something that's becoming more attractive to smaller businesses, if not on their own, then through third parties that want to sell them those services like you just talked about. So I think that is something that smaller businesses are doing. And I can come up with lots. I mean, again, I've told you I'd prefer there be no threshold at all that just apply to anybody that's in this business or in the space of collecting and using this data. But that's not realistic, and I can't pass that. I think 100,000 is too high, so I'm considering anything less than 100,000.
Oh, thank you.
Thank you. And Senator Westerfield and Mr. Kingman, and going to that 100,000, I'd be curious if we have any evidence or explanation how the other states picked that number. I don't want to
speak for Mr. Kingman. I think it was a negotiated amount.
Okay.
The coalition worked in Virginia. I know that they may have had some role in Colorado. We spoke yesterday at length, and we spent a lot of time about Virginia because that's their preferred model bill, so to speak. But they may have been active in the Colorado effort last year. I don't know if they worked in Washington State, but I think the 100,000 was negotiated in Virginia. And again, you can make a valid argument for having it there because Virginia's done it and Colorado's done it. I just think it's too high.
Mr. Kingman, do you if today Senator Westerfield was proposing a committee sub to adopt the Colorado/Virginia bill, would your organization be silent, in favor, or against it?
No.
Yeah, so we advocate the Virginia model. We think that's the best. So if that's where the committee was going, we wouldn't object to that. Would it be possible?
Would you be against it though, or would you?
No.
You would be a pro.
Yeah, I don't know. Yeah, we would certainly not object to it. We would not oppose it. We would not work against the Virginia model going forward. Would it be possible just to address the small business? I can address it sort of in the context of the 100,000, but to
you have
address
2
the senator's
minutes.
question on small business compliance.
If you can do it in 2 minutes.
Okay, great. So the 100,000 number was picked because California, when the CCPA was passed, that was the number there. 100,000 consumers was sort of propagated across Virginia and Colorado to keep it uniform so that everybody had the same sense of application. In terms of small business compliance, the reason that the compliance costs escalate quickly is that you have to hire privacy counsel to draft these lengthy privacy notices, and they have to be done in a very careful and specific way. There's IT architecture to be able to provide the opt-out requests, whether that's for targeted advertising to profiling or the sale of data. There needs to be an architecture built to be able to collate access requests so that somebody wants to access their data, that they're given their data back in a meaningful summary. There are contractual modifications with all of your vendors about requiring, negotiation about what they must agree to meet the requirements in the particular bill about how they treat data once they're in receipt of it. And so there are really any number of components to it that quickly add up.
Okay.
And that's regardless of whether it's a small business or
Thank you.
a larger business. Yep.
And
no
we will certainly, if you want to email us, we can distribute any other written concerns or comments to the committee. And Senator Westerfield, you have the final 5 minutes, sir.
Mr. Chairman, thank you. I want to thank Mr. Kingman for his time yesterday again, and Kate Lucent there with the coalition. And I expect we'll have another call or two before it's all said and done as I continue my work on a committee substitute. But I want to draw your attention to what he said there. His remarks just then, his remarks in his principal remarks earlier. This is the constant theme. All of the problems that Mr. Kingman, with respect to him and the coalition, all the problems that they and other business interests and other groups that are advocating for this or that are advising caution and concern, they're all built on the assumption that the status quo remain the same for them on the data that they can collect. On my call yesterday for an hour and 15 or 20 minutes with them, repeatedly I kept bringing up, they would say that this is going to be a burden on business, that they've got to comply with this and do that, and I kept saying, but that assumes they continue to collect the data that they've been collecting unabashedly and unabated for years and years. Something's got to give. Does this mean that it's going to have some costs for businesses? Yeah. But they don't have to do that. He mentioned long disclosures and privacy notices. Well, you don't have to collect it. If you don't want to hire an attorney to draft a big, long privacy notice because you're worried about whatever, then don't collect the data. There was a time when the businesses that existed did so without collecting my birth date and what my interests are and what I clicked on the website before I came to your website and where I go to next. It all assumes that they can continue the gravy train of data coming to them. That is the problem that I have with the objections raised so far to the bill. I'm fine with keeping that gravy train running, so long as consumers are informed and they have power over the data that is so rich and so valuable to the companies, small or large. So I continue to be frustrated because the assumption is, well, in order for us to keep doing what we're so used to doing, it's going to be so hard to comply with all these things. Well, you don't have to keep doing what you've been doing. Everybody, particularly the biggest players, but everybody that's using data has grown accustomed to there not being any sort of regulatory framework to speak of. The FTC has done a little bit, but not very much. And the biggest thing to date has been the EU's GDPR, the Global Data Privacy Rule. But here in America, there's only these 3 states that have gotten something on the books that affirmatively provides some sort of power for consumers. And now the business interests in the state or in the country are starting to take notice. And I think something's got to give. And I'm tired of what's giving being the consumer. Thank you.
Thank you, Senator Westerfield. Thank you to our guest witness, and thank you to everyone in attendance for following this topic. Seeing no other